Hello, viewers. We thank you for always listening and we thank you for always watching. I salute you all. Today, the topic of emphasis is strict liability and negligence, basically known as tort law 2. It is basically started in year 2, semester 1 and semester 2. So, in this essence, you have to understand that the law of negligence and strict liability started earlier ago. However much it wasn't in existence. But by the growth of law, the introduction of the new law, what we can call the repealing of some laws, so it ended up the coming of the tort of negligence. What you have to put in mind before is that the tort of negligence was basically existed because there was the thought of the thought of trespass, which means where they could find that someone has no intention in doing any act, then that person could not be held liable for the circumstances or for the action done. But after they realized that even the person can get any problem, any injury due to another person, however much there is no intention, as we have seen in trespass and other torts, then they say it would be better if we create what we call the of law of negligence and the law of nuisance. So in this way, what you have to put in mind is that uh, negligence has existed for years, for ages. It started in the case of Winter Bottles versus Wright, in the case of Frederick versus Bender, but in the case of Frederick versus Bender, it acted under contractual obligation. So, after, in 1932, the landmark case of Donoghue versus Stevenson established what we call the key principles, which was laid by Lord Atkinson. And this was uh, the neighboring principle, duty of care, breach of duty of care, and injuries resulted from the breach to the plaintiff. What do I mean? That after the case of Frederick versus Bender, um, the tort of negligence only acted under contractual obligation, that for you to be held liable under the same circumstance, you must have a contract with another person. But they said, not. Put this in mind that even if there is no contractual obligation, as we have seen the case of Donoghue versus Stevenson, where the person who got a problem from drinking a ginger beer was a third party. This is Mr. Donoghue went into uh, a restaurant, or you can call it a bar. He ordered a drink. By the time he was drinking, he found a residue made like snail, then under the bottle. Then he sued the product, the product maker, the producer, the manufacturer. So in this case, the manufacturer was liable. However much he was not the person who served the drink. He was liable because under this case, Lord Atkins, I have said that he established the key principle of neighboring principle. And in the same case, he defined who can be a neighbor. What is a neighbor? And he said that a neighbor is that person who can be affected by your actions. That is the person whom he termed as a neighbor. So put that in mind. So as we go far, and we have to talk about several elements. Another, principles laid down in the case. So we have duty of breach, duty of care. What do I mean by duty of care? That every person, let's say you are a manufacturer, you are under a contract, under supply of services, under an obligation you are taking, you have to make sure that you owe the duty. You owe the duty. You make your work uh, very well in the essence that you should not, you should not affect the person who is going to take the same product, or the person who is going to be served by your own actions. So anything that you're doing should not cause any injury to a neighbor, as it was laid in the case of Donoghue versus Stevenson. Now, when you look at some elements under the duty of care, we have reasonable foreseeability of harm. What do I mean? That uh, it must be foreseeable that what you have done, uh, and what you have done and the result was likely to cause harm. So this was seen in the case of TPP versus London Country Bus. So in this case, uh, the bus driver parked the bus and left the key inside. And as he went, uh, the thief came and took the bus, stole the bus. So it was foreseeable. However much the case didn't succeed, because you cannot even think that if I leave the key in the bus and I go, however much I left the key, someone can come and take what we call the bus. But it was foreseeable that in this case, that if you leave uh, the key in the bus, then someone can come and take it. But the case didn't succeed. What do I mean? That foreseeability means that even the reasonable man, what can a reasonable man see? Take an example. If they bring you and they say that you're a doctor, and you say yes, you're a professional doctor, and they ask you, um, can you leave any instrument in the patient's body? When you say no, that is the test they have made. But for a reasonable man, they will ask another person. Take an example. It is an accident, and they ask you in the road, they ask you that if I'm driving at a high speed, what is likely to happen? And you say accident. It is foreseeable that if I drive at a high speed, then the accident will happen at any time. That is foreseeability. And duty of care, you owe a duty. Even they say that the driver owes a duty to the passengers and other road users. It was seen in the case of Kato versus Kampala Transporters Limited. Now, another ingredient under duty of care, we have what we call proximity. We see the close, the relationship, the closeness. How is the action close to the causer? Someone who has done the action. How is the result close? So in this we see the case of Bonhill versus Young. In Bonhill versus Young, court held that the proximity, that there was no relationship between him and the defendant. What do I mean? In this case, we saw where Miss Bonhill's family was injured, and Bonhill was, the family of Bonhill was injured. Then they called Miss Bonhill to come. They called him. They called her. At the time he reached at the crime scene, then he got a nervous shock. So the court held that there was no close relationship over the same essence.